work, proof of ownership, and the websites. Sometimes we can do grand events where we are launching our works, and if somebody later on uploads our work on a platform and we want to take it down, we can show that, you know, this work has actually always been ours, and that is enough proof. So when we limit it to a certificate of registration, we are doing a disservice. One of our challenges with copyright registration in this country, first of all, it is very expensive. The application is 50,000. Gazette is anywhere between 150,000 to 500,000. So it means if we put this provision here, people will not be asking for takedowns. So we shouldn't defeat the purpose of the amendment and the takedown. Then plus how long it takes, because when you register, then you gazette and wait for 60 days. But 60 days, people are exploiting your work. And the moment you discover your work online, you want it immediately taken down. So we should simplify the process instead of making it cumbersome.
From what I'm understanding, you are saying,
original works, different drafts. There's metadata. There is agreements and licenses, website URLs, and also, but it is also other proof of ownership that we've been using, which is sworn affidavits. Yes. So all these different types simplify the process of, should be used to simplify the process of getting a takedown order, as opposed to limiting it only to one.
Yeah, I wanted to clarify. You see, that certificate that they asked for, groups like Afrigo that have sung for 50 years, people like me, songs were uploaded 30 years ago, but uploaded by people that are not us. When you want to take down a song that is put by DJ Echo, let me say, what they do is they already own, they want to show that they own what you produced. So when they ask for this certificate that I don't have, that means the takedown will be difficult. So the reason why we want to say that this, when they ask for the certificate, there are so many creatives that their works are already used for so many years. And someone claims, because when you upload, YouTube asks you who is the owner, then you say yes, because it's a computer you're talking to. So these would be the bottlenecks that would face after the law is passed. Would look into the certificate thing. There are those moral rights where a person is ragadi ayimba kamukube mpeta, and everyone knows it. And in America they don't know, but in Uganda they know. So the takedown will be difficult if they ask for this. So for us, what we want to simplify this. So many people have been into this trap. They have fallen into this trap, and the only way to help this is to look into that certificate thing. Thank you.
Chair, page 14, clause 25, which is introducing a new section 67A on mandatory annual general meetings for collecting societies. We observe that annual general meetings are important for purposes of strengthening governance and accountability in the collecting societies. Chair, for clarification, collecting societies are organizations set up and owned by copyright owners. And these societies actually work for the copyright owners. Currently in Uganda we have 3 licensed. One is Uganda Reproduction Rights Organization for literary works. Uganda Performing Rights Society for music, and Uganda Federation of Movie Industries for film. So those three currently, they are the ones that we have, and they are the ones that this article is seeking to support. So we agree the annual general meetings to happen in these for purposes of accountability, good governance, and all the other things. However, subsection or subclause 3, which imposes criminal penalties of up to 10 years imprisonment or Uganda shillings 50 million on executive committee members for failure to hold an AGM is excessive. This is a governance lapse, not criminal misconduct. And such penalties violate the principle of regulatory proportionality. Moreover, the executive committee, the people that serve on the executive committees of these organizations, do so on a voluntary basis. They are not day-to-day staff of the collecting society. So when you penalize them excessively with the 10 years imprisonment or 50 million Uganda shillings in fines, it is draconian. So such harsh sanctions risk discouraging qualified individuals from offering their leadership and expertise to the sector. Mr. Chairman, in fact, I'm expecting that if this clause passes the way it is, in the next 1 week, we shall see resignations of body members.
Chair, I am the chairman of the film sector. If this law passes like this, I resign the next morning. Why? Because when you're doing voluntary work and you see a clause like this, where government does not pay anything to run the CMOs, it is very, 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 very difficult. So we want to look into that clause very clearly, because all the people that have been working, Yo-Yo is I don't know where he's gone. Yo-Yo, Mr. Wasula has run UPRS before. It is difficult to run something that you're not helped. And when you put a law like this, people take years without doing AGMs because they don't have funds to do stuff. So people will be arrested. And no professional will allow to do such a thing.
But in my thinking, if we are to qualify the CPR system and there is a fund to run the industry, why would you be opposed to such a regulation, a penalty?
Chair, the force majeure, is that
first of all, it is done with discretion, and where you fail to conduct an AGM, there must be reasons. Where you fail to attend, why would you fail? Of course, if there are genuine reasons, you wouldn't be penalized. But if the PR system is in place and there is a fund, honestly speaking, the AGM is mandatory. Yes, sir.
Thank you very much, Chair. First of all, your assumption is a good one, but also unqualified. Why? Supposing we pass the law, the PCR is not passed, but this is passed. How will you change it? It will have gone. So we have to balance our arguments and put in perspective the real life experiences. When I was running UPRS, we were putting in money from our pockets. And holding an annual general meeting requires money. So if you don't have the money to hold the General Assembly, how are you going to hold it? The society itself has not started licensing. Euro, for example, is not licensing. But the law says Charles Batambuze will be imprisoned for 50 years. But the society is not licensing. Even the board members here. So the real life is, first of all, it's not proportionate. You cannot imprison me for such an administrative matter. Why? If you don't pass bills in your life, your calendar term as members of parliament, Should we arrest? Should we arrest you for not passing laws in your term? The bills were presented, but because of circumstances beyond your control, your term lapsed before passing those laws. So should we say even MPs who do not pass their bills in their parliamentary term should be charged and imprisoned for such a time? No, because there are circumstances that actually impact on your not passing the laws. Similarly, it's not in the interest of any board member or any CEO not to hold an AGM, because that's an accounting process. But circumstances beyond their control, like I said, you don't have the money. Euro doesn't. Even UFMI, Ragadi will tell you they're not licensing anybody. How are they going to hold AGMs? So let's remove this, because it is excessive.
Yeah, that is very true. So what are you proposing? What are you recommending?
Expunge.
Chair,
Let him first finish.
Chair, we are proposing proportionate administrative penalties. For instance, the registrar should be issuing administrative, compliance directives, the suspension of leadership. Because if you're on the board and you have not delivered, you have not had AGMs and so on, a suspension or removal from the board would be proportionate. Imagine you have been chair of this powerful organization and you are dropped, even the media knows, this is because you failed to perform in the function of AGM for accountability and governance. That is fair. Otherwise, the other issues are handled by other laws. For instance, if there has been a theft, that would be handled by the relevant laws. That one is clearly criminal. And other issues. Chair, this chairman of UPRS wants to say something.
Please. Please.
Also in the current act, that is already addressed. I think it's 697, where it states that if you, thank you, in the current act, that is already addressed. So that was, this particular clause, this new amendment, in my opinion, is simply draconian. Because in the current act, it states that if the running board fails to, I think, to commit still, I don't know how exactly it is stated, but then what it says is that, and again, it does not have satisfactory reasons, because it has satisfactory reasons to the registrar, then the registrar can always grant an extension. But in the event that it does not have satisfactory reasons, then it is automatically disqualified from office. That is what the
Council, is it so?
I think it's 697. I can. In the current 2006 Act.
Says you can amend it.
And we are going to chair. This particular board, we serve on voluntary basis. We are not being paid. So for you to come up with a draconian amendment is simply going to scare away professionals from wanting to serve the industry. Thank you.
Yes.
Thank you, Mr. Chair. I want to take distance from my colleagues because the problem we have, Mr. Chair, our law is a bit, has been ambiguous for some time, like ever since it was created. It does not differentiate check this collecting society. So for me, I'm looking at my colleagues trying to cut the cloth according to their sizes, and we are going to keep losing that. So this provision should not be expanded. It should be just streamlined. But when you talk of expanding it and removing it, why are you removing it? Because, Mr. Chairman, these collecting societies, most of them have taken long without making this mandatory. The annual general meeting. And in the annual general meeting, it is where...
Point of order, Chair. Point of order, Chair. The member is not in order.
Point of order? Yeah.
The member is not in order. Uganda Reproduction Rights Organization has held its AGM last year. Uganda Performing Rights Society held its AGM last year. So when he says they have taken long without holding AGMs, what is he saying?
Mr. Chair,
of course.
Mr. Chair,
Yes.
I belong to the field sector. So when he talks of the reproductive and the others, I belong to the field sector. And the issues we are facing within the field sector are different from maybe others. So, Mr. Chair, we cannot talk of the annual general meeting depending on the PCR. And that issue has come to your table, that if we don't have the money, because the collecting society has responsibility when it gets money, even when the PCR is not yet here. Because this is a statutory organization, Mr. Chairman. It's not like the Uganda Film Association where it will depend on its strategies to get money. The money which the collecting society has to have is within the law. So it has the money, the PCR is an additional money which is coming to the industry. So I am not saying it should be 10 years of prison or 50 million, but I am saying it should be streamlined to make it an enforcement. It should be an enforcement.
Thank you. I think the reflection we have here on record is that you are all in support of the mandatory annual general meetings. And you are also in support of the administrative sanctions. And not this penalty, which is criminal. And the proposals are, say, resignation, dismissal, and any other suspension, and not this one, which looks harsh.
Actually, Chair, the existing provision is enough. If you don't hold a general assembly within the specified time, you vacate office automatically. That's the law. So it's just a question of implementing it.
Chair, what I was saying,
yes.
to supplement this point.
Yeah, in 1 minute.
Yes. I think my colleague is also misinformed on the fact that these CMOs are registered as limited by guarantee. It is not right to say that they become owned by the regulator and the executive. Oh.
Okay.
Yeah, so I was just bringing to your attention that the CMOs are registered as limited by guarantee companies, meaning they belong to the members. So,
yes, in 1 minute. Yes, Council.
Chair, I think let's vote to expand that provision because I think its background was intended to punish the CMO system and and its leaders. But like my colleagues have said, or my clients have said, that already there are provisions for this. They're already there. It's self-contained. This is a company limited by guarantee, so the AGMs are already provided for, and I think also the Copyright Act does provide for them. So for us to have this is a bit punitive and a bit misplaced. That's why we have the view that let it be, because already the system takes care of itself. And maybe the other thing I would also want to add, which is that the failure of the CMOs to be compliant with some provisions of the Act or the law is not entirely up to them. I think that is where I should stop. It's not really entirely up to them. There is so much that has to be done to encourage this to encourage the CMOs to be active, but the law already takes care of those situations.
All right,
Thank you, sir.
Thank you. The committee takes note of your desires, and that the penalty is already captured here. We will study it further. Please go right ahead.
Chair, that marks the end of our submissions.
All right, thank you so much. We are very grateful members. It is already 15 minutes past 2. We would welcome some reactions, if any, and probably we can do that in the next 10 minutes. Members,
Mr.
any
Chairman,
reaction?
can I say something?
Yes.
Chair, though it's not on our presentation, but the question of artificial intelligence is a matter that must be addressed in the Copyright Amendment Bill. Because you co-create content with AI. Who owns the copyright? How are you going to do it? Secondly, AI cannot create content independently. It uses existing files. Where does it get permission from to use my content to create a new product? So actually I wrote to the committee on this matter as an individual, and probably I was guided by Honorable Basaliwa that we can appear as individuals. I don't know whether that's okay, but the question of AI, it must be included in the law so that how it works is guided by law.
Thank you so much. I see there is no any reaction. Yes.
Thank you, Chair. And want to thank our stakeholders for their presentations, and I think they have been clear on most of the issues they are conversing. However, I have a concern about the registration, which they seek to be excluded in the law. That the necessity to register. In my view, it is very important to register because registration has got benefits which should be able to protect the rights of our stakeholders here. Registration is a legal provision. It gives you a legal identity. It protects your name for a long time in perpetuity, up to your estate, even when you have gone. And it is something that we can use to protect against the piracy. And these days, the registration process may look cumbersome, but it is quite fast. It's quite fast. It also helps you, when we are talking about PCR, it helps to determine who benefits from the proceeds of PCR, other than everybody coming up to claim that I also deserve to benefit and so on. So in my view, and actually to ask and to persuade. Don't you think that it is important that we put registration as a condition? Not a condition, but it's a necessity in my view. Other than to say that we may not need it. It also helps the government that you seek to, because the government also seeks to will benefit from this amendment here, and it helps to determine how it taxes, yeah, for the tax obligations for each. So can we still continue to say that registration should be kept out of the question in this amendment? That is the clarification that I wanted to seek from our stakeholders. Thank you, Chair.
Chair. You know, there is what they call reality. We are trying to run away from the problems, and we don't need to bring problems. I am a practicing artist. I have about 300 songs. Now, having 300 songs and I register every song, I'll be broke before I finish my process. Why? It is very expensive to gazette a song, to pay for it. Roughly, one song I'll end in 400, 500,000. Now, after paying 500,000 for 300 songs, I'll be out of business. So for the young artist who's coming up today, he does not even have money to go to the studio, cannot go to USB to register a song. But you know that copyright does not begin with you writing something. It begins with how you produce your content and how you do the metadata. If I'm uploading a song, I put the producer of the song, I put the writer of the song, I put the owner of the song. So for us, we're trying to do something that is going to help. We do not run away from registration, but we're trying to tell you where the problems are. This industry is going to collapse. Why? Because there are so many difficult steps that people have to follow. Today, we talked about takedown. The rich people who have data, who have computers, are the ones uploading the songs and the films for the poor people. Now, if we need to consider some few things. The reason why we're having problems since 2006, the digital era had not really come out very well. We're thinking about the tapes and the DVDs. Now there are not tapes and DVDs. Like I talked about the digital bottlenecks. So now what we think is we want to create a law that will help harness the problems that we're facing right now. Presently, if you tell us to register all our songs, we'll not do it. Why? Because it is expensive. Imagine a person with a movie, about 10 movies, to register them. By the time they finish, they have not sold anything. Thank you.
Chair, I just want to attend to his question. Whether this, as encouraged in this bill, we should keep the mandatory registration of contracts, because that's what the bill is talking about. And already we explained our challenge with that. One, that provision talks about voidability of contracts. And that's where the problem is. Because if I've entered a contract with Emma Carlos of 1 billion, and I've already given him some money, and we delayed the paperwork for 60 days, the contract becomes void or voidable. And we explained what voidability means in our case, that okay, the two of us, it is still binding, but to third parties, it is not binding. And that's where the problem is, because the challenges that our industry faces is because of third parties. Third parties who exploit our work without authorization. And so that's one factor. But the other one is, Why should we deny people their property rights? Simply because after 60 days they say your contract cannot be enforceable. It's not fair. Why isn't the same thing applying to, say, landowners? Why isn't it applying to other property owners, but only to us who own copyright, the property called copyright? So we want to be treated equally, like all other citizens. I submit, Mr. Chairman.
I'm just adding to what Mr. Batambude was mentioning. The other effect that has to, as we move forward like other societies have moved, copyright or royalties or the works creatives do are used as collateral to acquire financial facilities and stuff like that. Now imagine a situation where at a certain time it has to go away. So that means no financial institution can trust a person who has maybe got this catalog for this amount of money, and then you're telling me after 20 years you won't be able to have it. It may affect more especially financial institutions that are giving you development grants or loans or something that take a lot of time, like 30 years or 25 years or something like that.
Thank you, Mr. Chairman. When we look at this issue of registering copyright, I don't know whether it's another way of creating an avenue for URSB or any other institution to make money. Yeah. First and foremost, do we have value for that money? When it comes to collateral, intellectual property is not considered in all institutions which are financial. They don't consider intellectual property. It would have been better if I happen to register my bank password and I get to know when I happen to take it to a bank, I can acquire a loan. So what is the meaning behind the registration of the copyright? We talked about copyright occurring where it has been created. It's already mine. Fundukuri is already mine. So if you're telling me to register it, what is the value of that registration? Is it possible for the financial institutions to also consider intellectual property as collateral in regards to the creatives acquiring loans or any other service from the financial services? So we need value for that registration. Thank you.
Chair, I wanted to give comfort to the member because he talked about NTR for the registrar, non-tax revenue. I want to give comfort to the honorable member that this sector actually is contributing a lot of non-tax revenue already. If you think about concerts, for example, we are paying UCC for a permit, we are paying KCCA, we are paying URA, we are paying NEMA, we are paying police. So that's a huge, huge sum of money that goes into NTR for government. Number two, take comfort in the fact that we actually pay taxes. Just to give the example of coloring back tunes, the celebrities which we talked about here, the total value of celebrities, all of them in 2019, was 78 billion Uganda shillings. Government took away 50% of that in taxes. And what are celebrities? It is music. So, in terms of value from this sector, already the government is gaining. So, we would love that this law does not increase our cost of doing business because, I mean, that paperwork, you have to invest probably in a lawyer to do it for you. It is not only the fee that the regulator will set, but even the process, investing in that process and the delays, because we want, but also the disposition of property when you don't file the papers within 60 days. That disposition is unconstitutional.
Thank you very much, Chair. Away from that, you see, actually, registration of these contracts is a veiled attempt to compel the registration of copyright. Because when you go to register the contract, they will say, are you the owner? Prove that you are the owner. Where is the registration certificate? So it's a veiled thing of actually compulsory registration of copyright. Yet, we are parties to the WIPO treaties, we are party to the Berne Convention, we are party to the TRIPS agreement. All of them say copyright is not registrable. The registration of copyright is optional. We do not stop it. We have people like Bebe Cool who have registered their copyrights. If you feel you want to register, go and register. If you don't want to register, let's follow the best practices, the global good practices, and that's it. So the question of registration should not come in discussion at all.
See, the committee chairperson is back. Mr. Chairman, once again, I want to thank you for the delegated powers during the time you were away. We have had a very constructive engagement with the stakeholders, and a number of issues were captured by both the Secretariat and the committee. And the exchange has already been done. And since we are coming to the end, I would want to let you know on a few issues that were discussed here. The first one was, and which is very key, irrespective of the numbering, was the establishment of the CPR system, where PCR system, yes, PCR system, where a CPR fund should be established. Yeah. That is one. The second one was the fair use of works, where we talked about the exceptions in regard to the orphans works, and then the collective loyalties. The third one was the mandatory AGM meetings, and the already existing sanctions, administrative sanctions. They are completely opposed to the penalty of 10 years and the 50 million. The fourth one, Mr. Chairman, was the proof of ownership on the works and the takedown orders which infringes the online content. So they submitted here on the alternatives they would wish to have. Those also were captured. The other matter, Mr. Chairman, was in regard to the Office of the Registrar, which empowers the Registrar with quasi-judicial powers. And it was seen in conflict of interest. So they recommended a tribunal system, an independent tribunal system. And lastly, Mr. Chairman, was the provision of the reversion, which they recommended for deletion. In regard to the 20 years and the legal accuracy of the content. Mr. Chairman, basically, that has been the reflection of this meeting while you were away. It has been very constructive. And I must say we are proud to have them here, coupled with the number of views and the written materials here. I'm sure the committee will be able to get a very fertile ground to suit their situation. I thank you so much, our visitors and the rest of the members. I now want to hand over the delegated powers. Thank you, Mr. Chairman.
Thank you. Thank you so much. Yes, Honorable.
Thank you, Chair, and welcome back. There is one thing that I've just recalled, and I wanted to bring it to the attention of our stakeholders here. you recall yesterday the Attorney General gave an explanation on this issue of reversion, which in my view was, the way I understood it was in the protection of the rights of the copyrights of these people, yes. In that he said that you, the owner, and remember we were associating it with the owner and then the lessee. In his view, you, the owner, owns your copyright in perpetuity, yes. But over time, with these dynamics in society, the value for which you may have, leased your right or leased your property may lose value, and so providing that it reverts to you after some time would be benefiting you, the owner, other than going with the other terms which have lost value through some time. How do you look at that? Yes.
I can. Yes, I think it is a two-way sword. I'll give you an example. Government wanted to help the Kadongo Kam sector, and they had agreements, what they call bad agreements. A person would buy a whole album at 3 million. Now the music became more expensive when it became old. I don't know if you're getting my point. So by the time the artist sold the music, he did not earn anything apart from the name. That people would say, oh, Kadongo Kamu, Sebata is doing very well. And today, when Shiba does the remix of the song becomes more expensive and more profitable. So the bad agreement will tell Kasiwukira that now I'm waiting for that remix to earn new money. But the artist who sold all his rights has lost it. Now there were bad agreements where people signed, you should take forever everything. Those are the ones we wanted to revise, where people sold kabisa all their rights, and even when you want to collect for them at the level of the CMO, someone says, I own, and I have a signature here, own whatever that person did. So we're trying to look at what can be the best practice. Why do we call it the best practice? After 20 years, the family of Phile Bongole Rutaya would be so rich. But if the contract doesn't go back to them, towards Christmas, the songs come up. And the family would be earning out of that. But because they did a contract that would not be reversed after 20 years, they will not earn out of it. So why we call it a two-way sword? At one end, after 20 years, the family can start earning. The rights will go back to them. Or the agreement will say, it is now past 20 years when Phile died, so his family can now earn from their family, from the works. So what we are saying is, we need to be very careful when talking about the 20 years. One colleague has talked about music.
Let's be very clear.
Yes.
What do you want? You want the reversionary interests
Chair, I can...
in the law, or you don't want the reversionary?
I can step in here.
Or you want us to regulate the years, because we either want them or not.
We have submitted.
Let the head of delegation answer, because we understand your explanation, but you seem to be wanting the reversionary interest to remain, because Bongole Rutaya should be able to earn after 20 years. Or the other Kadongo Kamu who sold at 3 million, and then after 20 years it is probably $1 billion. So what is it that you want us to do?
We have put it in
What is the balance?
Yes. No, the reason why I was trying to explain, honorable colleague asked the question, that don't you think because with the meeting that you had before with the Attorney General, because the Attorney General was saying that 20 years thing is going to protect you. To protect
the artist, the creator.
The creator.
Yes.
But the reason why we're saying it is a two-way sword. Someone talked about...
No, don't use a two-way sword. So the Attorney General is proposing 20 years. What do you want?
Chair.
What do you want us to do?
Yeah, we have submitted that the reversion clause be removed.
Such that the one who sold this at 3 million and later the music gains value should never gain anything.
No, the reason what we have proposed instead is that reversion rights can be covered under the contract.
It should be contract.
Yeah.
At the time of the contract.
Yes,
and the time when you're doing your contract with the...
Okay. Okay.
Moving forward, Chair.
Yes.
My take on that one is that I'm not for the reversion and I'm for to leave the liberty to the contract.
That's what they are saying.
Because when property is property, just like you say you have a piece of land, today you set it at 3 million. And after 20 years you come and claim that because it has appreciated so much, so it should be reversed. Because
let me also warn you about the practical reality. Honorable, let me tell you what will happen. What will happen is that the artists, the creators, are going to be fleeced. This guy comes with a very good sugar-coated offer now, because now you see a lot of value in maybe 100 million. You are an artist, you are just a beginner. So 100 million is a big thing. Some of these boys and girls have never held even $1 million shillings. Someone is coming up with an offer of 100 million and says, I want this thing forever. Gendo guletaka wei yenze chintu chimpe forever. The offer looks very lucrative and sweet. And that's what will happen. They will sign those contracts without the clause for a revision maybe after 10 years or 20 years. And that's what will happen. So we are now trying to protect them under the law.
The same
Chair, plus the other point I want to make about, of course, we are looking at the artist and the juice contract, juice at that time. Yes, but we're also looking at the risk that the investor bears. This guy here is a manager of talent, Khalifa Ganaga, and is investing in Khalifa. He does not even know that Khalifa will become a brand, in a brand name in 10 years. And Khalifa might not become a brand in 20 years, but is continuing to invest and holding on to, hoping that in the 21st year, Khalifa will break through. So if Khalifa is reverting the rights in 20 years, but then breaks out in the 21st year, so the investor loses out. And we are saying our industry currently, we are short of investment. And yet we want to contribute to jobs, we want to contribute to all these things. Actually, in our discussion, we said that maybe the right of reversion is good, but maybe as a country we are not yet ready for it. It could come in the next amendment.
So we leave it to the contract?
Yes.
All right, that is clear. That is done. We'll leave it to contract, which council you had canvassed. You want to change
a point of clarity, Chairperson, on the issue of reversion. You know, we have two things of where property transfers. We have assignment, and then we have also licensing. The reason why reversion is extremely risky is because now it will kill the aspect of assignment, because assignment means that I'm selling to you, and this property is yours. Because we need to be mindful that maybe these ones are performing artists, my colleague Jaja Ragadi, but they could be creatives who create music just for the sale. I create my own music and I'm giving it to KS Alpha to perform. So we cannot impose in that kind of contract and nature that then the works will come to me, because for me my job is to compose and sell them off. Yeah. So we need to balance it to know that assignment is a character of property. I assign and I give you everything. You take perpetually. You can give it to Mirundi. You can give it to anyone else. I have no claim on it. Okay. So if we say that we are reverting, that means that we shall weaken assignment, or if to make it non-existent completely, sir. Yes, sir. I submit.
You have something useful to add?
Yes. I'm coming in on the side of books. You know, sometimes when we meet like this, there's a concentration of music, performance, and then they forget there's this other aspect as well. For us on the side of books, it is even more challenging. If you go for the educational material like textbooks, if you have to supply books to the ministry, they must be evaluated. So you can receive about even 20 manuscripts from other authors who have created. And out of 20, you have invested the hundreds of millions, and 200 can go through. So you have risked, you have taken that. But so you are now trying on these ones, about selling them, and before you realize, maybe they are even changing the syllabus. Like, you know, you are now on a new lower curriculum competence base. So before you already something else comes, maybe some things have changed. You have to improve on that book. So if you tell me that in 20 years you are reverting this, where are you leaving the publishers who are investing? So you remember, if you can remember, that this industry, especially of books, in the 90s, in the early, I think the 90s, it was still dominated by nationals, Macmillan, Oxford, and whatever, until we got local investors came in and said, no, we can do these things. We have brains here, we can produce our materials. So we been investing in this. So we are trying to say that we need to be very careful, and this people will even again go back and, you know, and they move out of this.
Okay, thank you.
Okay.
On the same? Okay. The proposal has been well understood. Because we are short of time. Unless you have a different view. If you are conversing the same view, it's well understood. Okay, thank you.
Mine, I was emphasizing furthermore what I mentioned earlier on regarding the same. But it's just not only safeguarding investors and other people. Take for instance, Mr. Wasul has been managing the Afrigos for what, over 40 years, but 50 years. But I'm very sure the Afrigo didn't make as much money as they've made in the last 30 years or 25 years in the beginning. Now, just imagine an investor invested in them in the first 20 years, and the industry was still shaky. And then as things stabilize, he's not getting anything. Now, how is somebody else going to invest money? Because the way you see the music industry today, it has a lot to do with people who have started believing in the industry and investing a lot of money. People are leaving other businesses and investing in music heavily. And the only way they will continue doing that and even attracting international investors is when we leave a space to wiggle.
And our ultimate objective of passing this law is that it should spur investment in the sector. So anything that's going to stagnate the sector, we must dwell with it. So on that note, I want to thank you, NCF, and your partners for coming to our committee. No, it's off. I want to thank NCF and all your affiliates for coming to the committee. Colleagues, members of parliament, thank you so much. Our staff, thank you so much. This is a very difficult time for us as MPs. We are up and down, but thank you for bearing with us up to now. We'll continue with this process next week. If there is anything that you have left out, you can still contact our clerk. We can still give you space next week to come and we intend to give it enough time, although we want to conclude by Friday. So from Monday, we'll be here. For now, thank you so much. Thank you for your time. Patrick, thank you for standing in for me. And I think with that, we stand discharged. Thank you very much. Colleagues, let's go to the stairs for a photo opportunity with these very important Ugandans.
UBC, inspiring Uganda. The stage is set, the teams are ready, and your voice could be the difference. Come wave your flag, sing your song, and back your favorite team as they battle for glory in the Total Energies CAF African Nations Championship 2024, right here on home soil.
Hello, Kampala, Uganda. In response to the national call of strengthening the traffic security, Good Products Group HGO brand has officially launched their